We have about a little bit under 10 minutes before our time is up, so I want to open up for questions and comments from you all. For a long time, I have been preoccupied, and I think Simon as well, and those of us who do trade, I tell my students, do you know that every area of domestic law is subject to appeal at some point in an international organization? So if you're interested in labor law, if it's not only IP, it's across the board. And of course, we know it at the World Trade Organization, where we do have an international court that deals with these issues, but it's state to state. And so somehow it seems to have worked, but still it affects domestic decisions all the time. And I like to say that it's a supranational regulatory body. And I mean, it deals with all types of regulation in all types of areas. Investor state is even more problematic, I think. And it's been going under the radar for a long time. I am involved with, my old law firm represents a lot of governments in investor-state disputes, and governments haven't been very happy with the outcome of investor-state disputes. Now, whether the merit of every case is different. So they're definitely, I just want, it's not going to be possible to retrace our steps and go back, because there's some value, I want to say, for these international organs, at least on the WTO level. The investor-state situation may be somewhat different because there really hasn't been, there never was a multilateral investment agreement. That because of all the opposition to it, and for good reason. And that is something that needs to be revisited. So it's so fascinating to me to come to an IP place and talk about patent law within the context of this broader debates that we've been having for a long time. I should continue to have. I'm now going to ask you if you would just raise your hands if you have questions, comments, and introduce yourself, if you can, and address yourself, if you have it, to a particular panelist. Do you have a microphone by any chance? Yes.
Is it activated? Wonderful. This is really high tech. My name is Ben Beachy, and I work at Public Citizen as well in our trade division. And I wanted to first make a comment about one aspect of what Eli Lilly is arguing, and then a question for all the panelists. In addition to, what Simon just laid out as the rather extraordinary procedural rights that Eli Lilly is invoking to be able to second-guess a domestic court decision, and some of the rather expansive substantive rights that both Raju and Sean addressed, and new expansive interpretations of expropriation, Eli Lilly, in its notice of arbitration, alleged that Canada has been denying it what NAFTA guarantees as a minimum standard of treatment. Like a lot of NAFTA terms, it's a very vague term. What do we mean by minimum standard of treatment? And what Eli Lilly is saying it means is that we have a right to not have our expectations frustrated. We do not expect this definition of utility. We do not expect the promise doctrine, and on that basis alone, Canada has violated NAFTA's provisions. This is an extraordinary interpretation of minimum standard of treatment. The United States government, when it has had to defend itself in a separate investor case, said if this were the proper interpretation of minimum standard of treatment, we would, quote, lose the power to regulate. We would lose the power to respond to emergent demands or respond to crises. The regulation evolves. Instead, minimum standard treatment means due process. It means you get your day in court. It means police protection and other basic standards. But the kicker is that increasingly these three-person tribunals under U.S. investor-state pacts have been interpreting minimum standard of treatment to mean exactly what Eli Lilly argues, that a foreign investor has a right to a stable, static regulatory framework that does not frustrate their expectations. Why can tribunals, I think this is important, gets to like the Supreme Court idea, the International Supreme Court, why can these three individuals make this determination? Because they are not bound by states' opinions. In past cases, the United States and three other governments have said explicitly, minimum standard of treatment is a very narrow provision. You get due process. It does not mean your expectations have to be honored. And a tribunal ignored those states' opinions. They're not bound by precedent. You can cite cases, but you're not bound by a strict definition of precedent. And there's no meaningful appeal system. And so there's a limited annulment provision for technical errors, but there's no meaningful appeal system. What these three individuals say goes. And so on this basis, 3 out of every 4 cases that have been won by an investor under any U.S. trade or investment pact have been won on this expansive notion of minimum standard of treatment. So I think this is a very dangerous provision and bears mentioning in the Eli Lilly case, because what they're essentially saying is your utility standard as it stands when we made the investment stands indefinitely. It must not change. Otherwise, you're violating this trade pact. And so the question is that we've seen, on the basis of this expansive term, we've seen a real surge in the number of cases. There were only 15 investor state cases launched in any given year, even though this existed the system has existed for 4 decades. Only 15 were launched maximum in any given year up until 2001. In each of the last 3 years, more than 50 investor state cases have been launched, as investors are seeing that there's increasingly wide interpretations of their rights, wider than afforded under domestic law, if they accede to one of these investor state processes. And the scope has been increasing as well. This is the first case brought by a patent-holding pharmaceutical corporation under a U.S. pact. And so the question is, given TPP, given TTIP, have an unprecedented number of foreign investors cross-registered, considering all the U.S. pacts that we've signed in the past. There's over 100,000 cross-registered firms between the EU, United States, and all TPP countries that would be newly empowered to take advantage of these investor state rights. What concerns do you have, or do you see it? Is there a reason not to be concerned? Is this all just a bunch of fluff and fear-mongering for what the expansion of this system to what I believe they're calling 2/3 of the world's economy? What ramifications would it have for access to medicines? What ramifications would it have for regulatory autonomy to set autonomous definitions of utility?
I know that folks are interested. I just want to make sure that there's nobody else that wants. I want to allow that to be responded by our panelists. But anybody has this urging desire to ask a question that could tack on, but because I know we're running out of time. Okay, then I'll let the panelists respond. Do you have any particular? Whoever wants to go first, Simon.
Can I start?
Yes.
I just wanted to make the point that I know that there are some critics of government action. I work at the Cato Institute, so I am one of those who like investor state because it allows companies to challenge what governments do and make them stop doing so much. And so people might think that I would be sympathetic to this. Isn't this a great way to put a check on governments because they're doing all these terrible things? They should just do less. I wanted to make the point that these complaints could be used to stop governments from doing something, or actually to make them do something. And there are a number of cases brought recently. I don't have all the details on this, though. There's only been kind of minimal reporting, and I don't think anyone has seen the claims themselves that have not been public. But there are cases against a number of European countries who gave incentives for solar and wind power, and then pulled back and reduced the amount of subsidies they were giving. And foreign investors who are benefiting from those subsidies have brought claims under investor state type provisions. I don't know exactly what the allegations are. I mean, it could be minimum standard treatment. It could be regulatory expropriation. But I just wanted to make the point that if there are any libertarians out there listening to this, we can't rely on investor state as this is the way to rein in government. It's not just that. I mean, it is partly that, but I think we need to think about it kind of more carefully and a little more nuanced. This is, at its core, I think, a way to take power from the national sphere and put it in the international sphere. And I'm not opposed to that in all instances. I just think we need to think carefully about what the implications of doing that are. It's not just a way to rein in government. It's just a fundamental shift in the national international system, the way we do global governance, the way we balance out national international powers.
So thanks for your question, Ben. I mean, I'll just highlight this, I suppose, it was really from my talk itself, which is that that bootstrapping which exists within this complaint, it would not be necessary to do that within the TPP. I mean, so the TPP makes it explicit that you can make lost profit claims without going to minimum standard of treatment, which is an incredibly amorphous term, and most of the really kind of aggressive and creative litigation is going on under that term. But this under the TPP would just be a straight up expropriation claim. And, so because it says both lost profits and lost profits from intellectual property, and the carve out isn't any different. So the carve out that I mentioned, which all the information after the comma, which destroys the rule, is the standard being advocated in the TPP, and is the standard that exists in other agreements now. So a lot of these agreements, you actually see the litigation, you shop around for your best bilateral investment treaty, you bring it under that. So the case against Uruguay was brought under a Swedish, I believe, or maybe it was a Swiss, one of the S countries in Europe. But isn't where Philip Morris really is located. But since corporations have a headquarters in every country in the world, you can shop around and you can find the best language and the best investment treaty in order to bring these types of claims. So it's a larger problem. I'll footnote quickly one other issue that I'm working on that appears, which is the issue of pharmaceutical reimbursement. So there is a strategy by brand name pharmaceutical companies to try to use the treaty architecture to put roadblocks into the use of government power to lower the prices of medicines. And whether that's through reimbursement systems like Medicaid or through systems of direct price control, which the UK used to have and most countries don't have now. It's really, most of it is being done through monopsony power, through reimbursement or purchasing systems. There has already been a claim in the United States that any kind of price control mechanisms based on a state is preempted by the Patent Act, and they won that one. So there is a theory that you can bring that's an investment type frustration of profit expectations theory that could be brought into these kind of claims. Reimbursement is a covered issue within free trade agreements. And so I believe that there's a burgeoning case that companies are looking to bring, that government systems that reduce price below what they would get in a market with atomized consumers and monopolied suppliers, that is a frustration of their expectations of profit from the patent, and that any of those kind of systems should be subject to bilateral investment treaties. And I think that's a real issue the public health groups are working on in this country with regard to the TPP. And it's after this kind of claim looks pretty reasonable, frankly, in comparison to kind of a challenge of a court interpretation of Patent Act. I mean, it really is got these systems blatantly and purposefully reduce profit expectations. It's their very purpose.
I think that's it.
Jorge has a...
Okay.
Did you have a question? Okay, please.
I'm not an academic. I'm a practicing attorney, and I just had some great ideas as you guys were talking. Let's assume, hypothetically, that I represent a Mexican company that has had for many, many years gene patents in the United States. And as you all know, Myriad Genetics was decided in 2013. The Supreme Court of the United States says all those patents that you all thought you had for 30 years, they were no good. The Patent Office of the United States made a big mistake, and simply isolating a gene from a chromosome does not confer eligibility or patentability. Let's assume that this thing violates expectations of a Mexican client who's had patents on genes for a long, long time. I would be justified, if this goes, to bring an investor complaint against the United States government at a NAFTA arbitration panel or something, complaining that these patents were an expectation of my client as an investor in intellectual property in the United States, notwithstanding the Supreme Court decision. Would I be justified in bringing such a case?
Yeah, you can. I think you can. And I think what goes around, what goes around comes around, and that's our concern, because we are highly concerned about the chilling effect of this case. If Eli Lilly wins this case, it will have implications for everyone, including the U.S., because now the Supreme Court has been taking the lead in terms of patent law and policy in the U.S. And certainly there are companies here in the U.S., there are companies from Canada and Mexico, and they're also frustrated with the Supreme Court's decisions. So the ISDS provides them a new venue to challenge the U.S. Supreme Court decisions.
I have a feeling that this issue may be addressed in the next panel. Yes, final question or comment.
Okay. I think it's worth pointing out, too, that we're talking about a country that can afford to litigate this for a decade. There's a lot of kind of anecdotal reports about public policy in the shadow of the investor-state arbitration system. At a recent conference, a Chilean law professor talked about a provincial government blocking international mining company from opening a new mining pit. Then the company threatens in the capital, Santiago, to the government, points out that they could file a claim, cause a lot of trouble. Then Santiago puts pressure on the local government. A month later, that company has provincial permission. Uruguay's defense against Philip Morris, when Philip Morris initially announced that they would file, Uruguay's legislature had a very intense debate about actually changing the law. They almost backed down, and it was when Mike Bloomberg stepped forward and said, "Don't worry, I'll pay the costs." His foundations, because of his tobacco control policies, his foundations are underwriting a lot of Uruguay's costs. Then the Uruguayan legislature kind of felt like, all right, well now, let's stand our ground. But governments it's affecting domestic policy. It's affecting democracy, even when it never gets to actually being a filed case that people like us then get to discuss.
The cost of investor-state dispute arbitration, and just arbitration, is such an important issue for governments. I used to represent a government that ended up paying $40 million for a case that it had to do with the Bataan nuclear power plant in Philippines. It never got mothballed, and it was such a travesty when you think about that, sort of thinking of arbitration as being cost-effective. It definitely is not. Having said that, I just want to say one concluding thing. It's very important to not view an internationalization as necessarily negative or less progressive, or that national courts as being able to safeguard rights better. It really is not such a blanket sort of a situation, and it's important for us to figure out how to mobilize. I want to just give the example of the environmental movement in the WTO. I think they have been very effective in sort of greening the system to some extent for themselves, especially in the dispute settlement, from where we were in 1999, Seattle, to the present. Of course, a lot has changed, and there's a lot to do. Thank you all for coming. Thank you again for inviting me. My voice is going for some reason. I didn't even talk. Thank you very much.